I don't know if you've ever lived next to a Karen before, but trust me when I say I'm living right next door to a textbook example. And when she, not once, but repeatedly, secretly connected my yard faucet to her irrigation system, the game was on. I tried the peaceful route, but sometimes justice needs to be served. The story of how the court ordered her to pay for every single gallon of water she stole from me turned out to be one of my sweetest victories. I still remember the look on her face when the judge read out the final damages amount. Have you ever witnessed someone's entire demeanor collapse in real time? It's oddly satisfying. I'd love to know what state you're watching from, and if you've had your own Karen encounters. Comment below so I don't feel so alone in this battle. I'd saved for years to buy this house. At 35, working as a tech consultant from home, I finally managed to purchase my dream property in what seemed like an idyllic neighborhood. The house sat on a corner lot with beautiful landscaping, complete with an efficient irrigation system, some particularly valuable given the drought conditions our region had been experiencing. I knew moving into a community with a homeowners association meant certain restrictions, but I figured the benefits outweighed the occasional rule enforcement. What I couldn't have known was that my arrival had disrupted someone else's plans for my new home. Her name was Patricia Wilson, but everyone in the neighborhood referred to her as Patty. Only later did I understand this was short for Patricia the Patronizing, the neighborhood's very own Karen. In her early 50s, with perfectly highlighted hair and a perpetual look of disapproval, Patty had once been a prominent HOA board member before losing her position in a community vote about 2 years before I moved in. I discovered through casual conversations with neighbors that Patty had some history with the previous owner of my house. Apparently, they'd been business partners once, and she believed she had some sort of unspoken agreement about purchasing the property when he decided to sell. Instead, he'd accepted my higher offer, leaving Patty bitter and resentful toward the new owner, me. At first, her animosity manifested in small ways: unsolicited advice about my landscaping choices, reports to the HOA about my garbage cans being visible for too long after collection day, and complaints about the color of my mailbox, which was the exact same shade as when I bought it. I tried to be neighborly, chalking it up to someone who simply took the HOA rules more seriously than most, but I couldn't help but notice something strange. While everyone's lawns were browning due to the mandatory watering restrictions, Patty's yard remained suspiciously lush and green. I might have dismissed this as expensive landscaping or perhaps a sophisticated drip irrigation system, but her sprinklers seemed to run with remarkable frequency despite the restrictions. I was working late one night around 2 a.m. when I heard a faint, unfamiliar sound coming from my backyard. It was a subtle hissing noise, almost like water running, but I hadn't scheduled my irrigation system to run that night, especially not during the early morning hours when water usage was strictly prohibited during the drought. Curious and slightly concerned, I grabbed my phone's flashlight and headed outside to investigate. What I found was both surprising and infuriating. There, partially hidden among the bushes at the edge of my property line, was a thin, black hose connected to my yard faucet. The hose snaked through the shrubbery, disappeared under the fence, and presumably connected to Patty's irrigation system. I followed the connection as far as I could without trespassing onto her property and took several photos with my phone. Then, after some consideration, I disconnected the hose but left it where I found it. I wanted to see what would happen next. The following morning, I checked my water bill online and was shocked to discover how much higher it had been for the past 2 months compared to what the previous owner had typically paid, information I had requested when budgeting for utilities. This wasn't just a one-time watering. This had been happening consistently. Rather than immediately confronting Patty, I decided to gather more evidence. I called my friend Mark, a software engineer who had dealt with his own HOA battles in the past. Document everything, he advised. These situations can quickly devolve into he said, she said without clear evidence. He offered to help me set up a proper surveillance system that would stay within HOA guidelines while capturing any suspicious activity around my yard faucet. Within days, we had installed a small, discreet camera that pointed directly at the faucet, well within my property boundaries and compliant with all HOA regulations. Additionally, I purchased a professional-grade water flow meter that could accurately measure and record how much water was being used and when. These weren't cheap investments, but as Mark pointed out, think of it as insurance against being taken advantage of. I also reached out to my neighbor Samantha, who happened to be an attorney, for advice on the legal boundaries of the situation. She confirmed that unauthorized use of my water was clearly theft, especially during drought restrictions, and suggested documenting everything thoroughly before taking any action. My patience paid off 3 nights later when my phone alerted me to motion detected by the camera. I watched in real time as Patty, dressed in dark clothing, sneaked into my yard around 1:30 a.m. She reconnected her hose to my faucet, turned it on just enough to create a steady flow without making too much noise, and then carefully arranged the surrounding bushes to hide her handiwork. The camera captured everything in perfect detail, and the flow meter began recording the water usage. This same pattern repeated 3 more times that week, always during the early morning hours when watering was technically allowed but when most people would be asleep. By the end of the week, I had video evidence of 4 separate incidents and precise measurements of how much water had been taken each time. I was ready to confront Patty, but I wanted to handle it in a way that wouldn't immediately escalate the situation or make me look like the bad neighbor to everyone else in the community. I decided to approach Patty directly before involving anyone else. On a Saturday afternoon, I walked over to her house and knocked on her door, bringing with me some pamphlets about drought-resistant landscaping that I'd picked up from the local garden center. An olive branch of sorts. When she answered, her initial look of surprise quickly transformed into that familiar expression of disdain. "Can I help you?" she asked, not bothering to mask her irritation. I explained that I'd noticed her beautiful landscaping despite the drought conditions and wondered if we might chat about some water-saving techniques I'd been researching that could benefit us both. I deliberately avoided mentioning the hose or the nighttime watering, hoping to establish some goodwill first. Patty invited me in with visible reluctance, and we sat in her immaculate living room where framed photos of her garden winning local competitions lined the walls, accolades that suddenly made much more sense given her illicit watering source. As I attempted to discuss collaborative solutions like shared rainwater collection or drought-resistant plant recommendations, she grew increasingly impatient. "I've been gardening for 30 years, she interrupted. "I don't need advice from someone who just moved in." When I gently shifted the conversation toward water usage and mentioned that my bill had been unusually high, her demeanor changed from dismissive to defensive. "Are you accusing me of something?" she demanded, her voice rising slightly. I decided to be direct but diplomatic. "I'm not accusing, Patty. I have video evidence of someone connecting a hose to my yard faucet at night. I wanted to discuss this with you privately before considering other options." The transformation was immediate. Her face flushed red and she stood up abruptly. "How dare you spy on neighbors? That's against HOA regulations." When I calmly explained that my security camera was fully compliant with all rules, she switched tactics. "That house should have been mine," she hissed, her composed facade crumbling entirely. "Thomas promised it to me before you swooped in with your tech money. I've lived in this community for decades. I have more right to that water than you do." The conversation deteriorated quickly from there. Patty refused to acknowledge any wrongdoing, instead threatening that she would make sure I regretted moving into the neighborhood. "You have no idea how things work around here," she warned, as she practically pushed me toward her front door. "Nobody likes a tattletale, especially not the HOA." True to her word, the very next morning I received a notice from the HOA about an alleged violation regarding unauthorized surveillance equipment on my property. Though I knew my camera was within guidelines, it was clear that Patty had connections on the board and was willing to use them. I called Samantha for advice, and she agreed to review the situation. After examining my evidence and the HOA bylaws, she was unequivocal. "This is straightforward theft, and the HOA notice is baseless intimidation. You have two options: either file a police report for theft or pursue civil litigation for the cost of the stolen water and related damages. She added thoughtfully, given the drought conditions and the value of water right now, this isn't a trivial matter. And considering the harassment you're receiving for simply protecting your property, you might have a case for emotional distress as well. As we discussed strategy, Samantha's legal mind clarified my path forward. Sometimes, she said, the only language people like this understand is legal consequence. Let's prepare a case that will make her think twice before stealing from anyone else. With Samantha's guidance, we began preparing a comprehensive civil lawsuit against Patty. The charges included trespassing, theft of resources, financial damages from increased water bills, and emotional distress caused by her retaliatory actions and threats. Samantha helped me document everything meticulously: the video evidence, the water meter readings, copies of my unusually high water bills, the baseless HOA violation notice, and a detailed timeline of all interactions. The strength of civil cases often comes down to documentation, Samantha explained as we organized the evidence. Judges appreciate thoroughness, and it leaves little room for the other party to create alternative narratives. The smartest decision we made was installing that professional-grade water meter, what we came to call the smart meter in our case documentation. This device had not only recorded the exact amount of water taken during each incident, but also time-stamped the usage and calculated the financial impact based on our utility company's drought period rates. Samantha recommended we frame the damages in the most comprehensive way possible. During drought conditions, water isn't just billed at premium rates, it's a limited resource with environmental impact. We should calculate damages based on the highest tier of water pricing, plus the administrative fees and penalties you could have faced had the water authority discovered your excessive usage. We also included the costs of installing the security camera and water meter, as well as reasonable compensation for the time I'd spent documenting and addressing the issue. Mark helped prepare the technical aspects of our evidence, ensuring the video footage was properly authenticated and the water usage data was presented in a clear, easy-to-understand format. He created charts showing the correlation between the nighttime tapping of my water and the spikes in my utility bill. "A picture is worth 1,000 words," he noted as he put the finishing touches on a time-lapse visualization of the water usage patterns, but a well-designed chart backed by hard data? That's worth a judgment in your favor. We also gathered statements from other neighbors who had observed Patty's unusually green lawn during the drought period, carefully avoiding mentioning our suspicions but simply documenting the anomaly. The day before we were scheduled to file the lawsuit, I received a text message from an unknown number. It was Patty, somehow having obtained my cell phone number. "I know what you're planning," the message read. "I'm willing to pay you $200 to forget this whole misunderstanding. No need to involve lawyers and waste everyone's time." I showed the message to Samantha, who simply smiled. "She's scared," she observed. "She knows she's in the wrong and she's trying to make this go away cheaply. This is good for us. It's essentially an admission of guilt." I declined Patty's offer, and the next morning we filed the lawsuit at the county courthouse. Patty was served with papers later that same day, and our court date was set for 3 weeks later. The game was now officially in the judicial system's hands. The morning of the hearing arrived with a mixture of anticipation and nervousness churning in my stomach. I woke before my alarm, rehearsing the timeline of events in my head and double-checking that all our documentation was properly organized in the folder Samantha had prepared. Though she had thoroughly prepped me for what to expect, this was my first time being involved in any kind of litigation. Courtroom dramas on television hadn't prepared me for the mundane reality of civil court. The slightly worn wooden benches, the fluorescent lighting that seemed just a touch too bright, and the pervasive smell of coffee and paper that filled the corridors of the county courthouse. We arrived an hour early at Samantha's insistence. "First impressions matter, even in civil court," she explained as we navigated through security, "and it gives us time to center ourselves while the other party might be rushing." The county courthouse was busier than I expected, with our case being just one of many civil disputes scheduled that day. People from all walks of life moved through the halls with expressions ranging from boredom to barely concealed anxiety. As we waited outside the designated courtroom, I noticed several familiar faces from the neighborhood, including Robert Chen and two other HOA board members. "Did you know they would be here?" I whispered to Samantha. She shook her head slightly. "Not specifically, but I'm not surprised. News travels fast in small communities, and this case has implications for HOA policies. Plus," she added with a knowing smile, "people are naturally curious about conflicts that don't directly involve them." Mark arrived a few minutes later carrying a laptop bag containing our technical evidence. He had taken a half-day off work to be present, understanding the importance of having someone who could explain the water meter data in layman's terms if necessary. "How are you holding up?" he asked, sitting beside me on the bench. "Nervous, but ready," I replied, grateful for the support. We reviewed our strategy one last time. Stick to the facts, avoid emotional responses no matter what Patty or her attorney might say, and trust in the documentation we had meticulously prepared. At precisely 9:47 a.m., 13 minutes before our scheduled hearing, Patty made her entrance. She arrived with not just one but two well-dressed gentlemen. Samantha immediately recognized the older one as James Holbrook, a prominent local attorney known for representing the HOA in various matters. "Interesting choice," she whispered to me. "He's good, but his specialty is real estate law, not personal litigation. She's calling in favors." The younger man carried multiple leather portfolios and had the harried look of a junior associate. Patty herself was dressed impeccably in a conservative blue suit with subtle pearl earrings and perfectly coiffed hair, projecting confidence and respectability, a far cry from the angry woman who had practically thrown me out of her house. She deliberately avoided making eye contact with me, instead chatting animatedly with the HOA board members as if this were a social gathering rather than a lawsuit. "She's playing to her audience," Samantha observed quietly. "Notice how she's positioning herself as the wronged party even before we enter the courtroom? Body language, tone of voice, even her outfit. It's all calculated to present herself as the respectable community matriarch." I watched as Patty laughed at something Robert Chen said, her hand briefly touching his arm in a gesture of familiarity. "Should we be worried?" I asked. Samantha shook her head. "Facts speak louder than performances. Just remember what we discussed. Let me handle the legal arguments, and you focus on answering questions truthfully and directly if asked." At 10:05 a.m., the courtroom doors opened and a clerk called our case number. As we filed into the wood-paneled room, I noticed it was smaller than I had imagined, with just enough space for perhaps 30 people. Judge Elena Rivera, a no-nonsense woman in her 60s with silver-streaked black hair pulled back in a tight bun, presided from a modestly elevated bench. Her reputation for efficiency and fairness was well known in legal circles, according to Samantha, who had appeared before her twice previously. "All rise," the bailiff announced, and the formal proceedings began with introductions and the establishment of the basic parameters of the case. After the initial formalities, Judge Rivera looked directly at Samantha. "Counselor, please present your case." Samantha rose with confident grace, thanked the court, and began methodically laying out the evidence of trespassing and water theft. She first established the context, the severe drought conditions, the mandatory water restrictions in our county, and the premium rates being charged for water usage, before moving to the specific incidents. She showed the video recordings on a laptop, highlighting the timestamps that corresponded with the water meter readings. The clarity of the footage was undeniable. Patty, clearly recognizable despite the dim lighting, connecting and disconnecting hoses to my property on multiple occasions. Mark had created a compelling visual presentation that overlaid the water usage data with the video timestamps, creating an irrefutable connection between Patty's actions and the unauthorized water consumption. The judge leaned forward, studying the evidence with keen interest, occasionally making notes on a legal pad. Samantha then addressed the financial impact. "Your Honor, in normal circumstances, unauthorized use of someone's water might seem like a minor inconvenience. But during a declared drought emergency, with mandatory restrictions and escalating rate structures, this theft had significant financial consequences for my client. Additionally, had the water authority identified my client as exceeding usage limitations, he could have faced substantial penalties through no fault of his own. She then moved to the emotional distress aspect of our claim, detailing Patty's retaliatory actions after my attempt to resolve the matter privately, the false HOA complaints, the threatening behavior, and the community intimidation tactics. This was not merely about water, Samantha emphasized. This was about a calculated attempt to harass and intimidate a new homeowner who simply wanted to protect his property rights. I noticed several of the HOA board members shifting uncomfortably in their seats as Samantha referenced the baseless violation notices that had been issued. When Samantha concluded, Judge Rivera turned to Mr. Holbrook. "Counselor for the defense, your response." Holbrook rose smoothly, adjusting his silk tie before addressing the court. His defense strategy quickly became apparent. Rather than denying the basic facts, which were clearly documented on video, he attempted to frame the situation as a simple misunderstanding between neighbors. "Your Honor, while the video evidence does show my client accessing water from the plaintiff's property, context is essential here. Ms. Wilson believed there was an informal arrangement with the previous homeowner regarding shared resources," he explained with practiced eloquence. "This was a community where neighbors helped one another, and she mistakenly assumed this arrangement would continue." Holbrook then pivoted to portray Patty as a respected, long-standing community member while characterizing me as overly litigious and unwilling to resolve the matter neighbor to neighbor. "My client has lived in this community for over 20 years, serving on the HOA board, organizing community events, and contributing to the neighborhood's prosperity through her award-winning landscaping that has raised property values for everyone," he stated. "The plaintiff, who has resided there less than a year, has shown little interest in community integration or understanding established norms." He emphasized Patty's attempt to settle the matter. "My client offered to compensate Mr. my last name for any inconvenience, but he insisted on escalating to formal litigation, hardly the action of someone interested in being part of a harmonious community." I felt my face growing warm as Holbrook painted me as an unreasonable outsider, but Samantha had prepared me for this. She had warned that Patty's defense would likely attempt to shift the focus from the actual theft to community standards and relationships. I maintained a neutral expression, though I couldn't help noticing Robert Chen nodding slightly during portions of Holbrook's characterization. Judge Rivera listened impassively to both presentations before asking a series of pointed questions. "Mr. Holbrook, you mentioned an informal arrangement with the previous homeowner. Do you have any documentation or witness testimony to support this claim?" Holbrook hesitated momentarily. "Your Honor, such neighborhood arrangements are typically verbal in nature. My client understood from conversations with the previous owner that resource sharing was common practice." The judge made a note before turning to Samantha. "Counselor, do you have any evidence regarding this alleged arrangement?" This was the opening Samantha had been waiting for. "Yes, Your Honor. We have the previous homeowner present today and prepared to testify on this exact matter." The turning point came when Judge Rivera asked if there were any witnesses. Samantha called Thomas Reeves, the previous owner of my house, who had agreed to testify. Thomas, a gray-haired man in his 60s with a dignified demeanor, took the stand and was sworn in. He calmly stated under oath that he had never had any arrangement with Patty regarding shared water use. "In fact, Your Honor," he added, "Ms. Wilson approached me about such an arrangement shortly before I listed the property, and I explicitly declined due to the drought restrictions." Furthermore, Thomas revealed information we hadn't anticipated. "I feel I should mention that Ms. Wilson was cited by the previous HOA board for similar behavior in 2018, when she connected to my neighbor Harold's irrigation system while he was away for the summer. I was on the board at that time, and we issued a formal warning after Harold filed a complaint." Mr. Holbrook objected strongly to this revelation as hearsay, but Judge Rivera overruled, noting that Thomas was speaking from direct knowledge as a former board member about official HOA action. Following Thomas's testimony, something unexpected happened. An elderly woman sitting in the back of the courtroom stood up and addressed the judge. "Your Honor, may I speak to this matter as well?" The judge, somewhat surprised, asked for her identity. "Margaret Winters, Your Honor. I've lived next door to Miss Wilson for 15 years and I have relevant information." After being sworn in, Margaret described finding unauthorized connections to her water supply twice during previous summers. "I never formally complained because I was afraid of retaliation," she explained, her voice steady despite her evident nervousness. Ms. Wilson made it clear that those who opposed her would face consequences through the HOA. She said something in English, and she translated the conversation to the people she was with. This spontaneous testimony seemed to open a floodgate. Another neighbor, David Patel, asked to speak and described a similar pattern of behavior he had experienced 3 years earlier. "I installed a locking cover on my yard faucet after discovering the unauthorized connection, and the following week received 5 separate HOA violations for supposedly unrelated issues." The courtroom had transformed from a formal legal proceeding to something resembling a community forum, with Judge Rivera carefully managing each testimonial to ensure its relevance. I watched Patty's face as these testimonies accumulated. Her confident demeanor had crumbled, replaced by a tight-lipped expression of barely contained fury. She leaned over repeatedly to whisper urgently to Mr. Holbrook, who seemed increasingly uncomfortable. When the judge asked if she would like to testify in her own defense, Holbrook quickly interjected, "My client will exercise her right not to testify at this time, Your Honor." After all testimony concluded, Judge Rivera announced a brief recess to review the evidence and testimony. The 20-minute wait felt interminable as we sat silently in the corridor outside. Patty and her legal team huddled in intense conversation at the far end of the hallway, while neighbors who had testified spontaneously came to introduce themselves to me properly. "I should have spoken up years ago," Margaret confessed quietly. "Sometimes it takes someone new to challenge the status quo." When we were called back into the courtroom, Judge Rivera had a stack of neatly organized notes before her. She began by acknowledging the unusual nature of the proceeding. "This case has clearly touched on community dynamics that extend beyond the specific incidents cited in the complaint. However, my ruling must focus on the legal matters at hand." She then delivered her verdict with methodical precision. "The evidence presented clearly establishes that Ms. Wilson repeatedly trespassed on Mr. Moose's property and diverted his water resources without permission," she stated firmly. "The video evidence is unambiguous. The water usage data is compelling, and the testimony of multiple witnesses establishes a pattern of similar behavior that undermines the defense's claim of a misunderstanding." She addressed the context directly. "Given the drought conditions and the premium cost of water during this period, I am ordering Ms. Wilson to pay restitution at the rate of $10 per gallon for all documented unauthorized usage, which amounts to $4,730 based on the submitted meter readings." She continued addressing the additional claims. Additionally, Ms. Wilson is ordered to reimburse the plaintiff $1,245 for security equipment and legal filing fees. With regard to the claim of emotional distress, the evidence supports that Ms. Wilson engaged in retaliatory actions after the plaintiff attempted to resolve this matter privately, including filing demonstrably false HOA complaints and engaging in intimidation tactics. For this, I am awarding $5,000 in damages. The total judgment came to $10,975. Finally, Judge Rivera addressed the matter of future protection. "Given the established pattern of behavior and the testimony regarding previous incidents, I am issuing a restraining order barring Ms. Wilson from entering the plaintiff's property under any circumstances for a period of 2 years. Additionally, I am referring this matter to the County Water Authority for review of potential violations of emergency drought restrictions." As the judge announced the final amount and additional measures, I watched Patty's expression transform from tense anticipation to utter shock. The color drained from her face, and for a moment I thought she might actually object directly to the judge. Her attorney placed a restraining hand on her arm as she appeared ready to stand and protest, but she remained seated, her face gradually flushing with what appeared to be a mixture of anger and humiliation. Mr. Holbrook quickly assured the judge that they understood the ruling and would comply with all orders. The gavel struck, concluding the proceedings, and the courtroom began to empty. Neighbors who had testified approached to express support, while the HOA board members slipped out quickly, avoiding eye contact with either Patty or myself. We remained seated until Patty and her legal team had left, Samantha wisely recognizing that a hallway encounter would serve no productive purpose. "It's over," she reassured me, "and the outcome is even better than we anticipated." As we finally exited the courthouse into the bright midday sun, the full impact of what had just occurred began to sink in. This wasn't just about recovering damages for stolen water anymore. It was about a community finally confronting a pattern of intimidation and entitlement that had persisted for years. The public nature of the proceeding meant that Patty's carefully cultivated image as a respected community leader had been irrevocably damaged. As we walked to the parking lot, Samantha gave me a satisfied nod. "That went even better than expected. The witness testimonies really sealed it. I suspect this isn't the last we'll hear from Patty, though. People like that don't take defeat gracefully, especially such a public one." Mark, who had remained quietly supportive throughout, finally broke into a broad smile. "You know what the best part is? Water justice is served, and now everyone knows exactly what was happening. Sometimes the truth just needs a proper venue." As we parted ways in the parking lot, I felt a complex mixture of vindication, relief, and a strange sort of gratitude toward the neighbors who had spontaneously come forward. What had begun as a simple property dispute had revealed deeper community dynamics that had needed addressing for years. The ripple effects of this day would likely continue for quite some time. News of the court decision spread through the neighborhood like wildfire. By that evening, I had received several text messages and emails from neighbors, some congratulatory, others concerned about escalating tensions in the community. The reactions split along predictable lines. Newer residents generally supported my stance against theft and harassment, while some long-term residents who had personal relationships with Patty felt I had overreacted to what they deemed a minor issue. One particularly pointed email suggested I had destroyed community harmony over a few gallons of water, apparently unaware of just how much water had actually been stolen over time. The HOA board called an emergency meeting to discuss what they termed recent legal developments within the community. I received a formal invitation, as did Patty and several other interested parties. Samantha advised me to attend, but to remain calm and factual, regardless of provocation. "This is their attempt to regain control of the narrative," she explained. "The court has already ruled in your favor, so you have nothing to prove. Just be the reasonable, rational person you are." The meeting was scheduled for the following Thursday evening at the community clubhouse, giving everyone a few days to process the court decision. During those intervening days, Patty launched what could only be described as a smear campaign. She went door to door to speak with neighbors, portraying herself as the victim of a vindictive newcomer who didn't understand how things worked in the community. She claimed I had somehow manipulated the court with technological tricks and that the judge had been unreasonably harsh. Most disturbingly, she began spreading rumors that I was using my home security cameras to spy on neighbors, particularly families with children, a particularly insidious accusation designed to make people uncomfortable around me. I learned about these rumors from Mark, whose wife had been approached by Patty at the local grocery store with these fabrications. When Thursday evening arrived, the community clubhouse was unusually full. Nearly 40 residents had shown up, compared to the typical 5 or 6 who attended regular HOA meetings. The current HOA president, Robert Chen, called the meeting to order with visible discomfort. "We're here to discuss recent events and how we can move forward as a community," he began diplomatically. "While we acknowledge that a legal judgment has been rendered, our goal tonight is to find a path toward neighborhood harmony." Patty sat in the front row, surrounded by a small group of supporters who nodded vigorously at Robert's words. I sat toward the back with Samantha and Mark, observing rather than participating at first. Robert invited Patty to speak first, which seemed procedurally questionable but not worth challenging. She rose dramatically, dabbing at her eyes with a tissue, and launched into a carefully rehearsed speech about her decades of service to the community, her award-winning garden that brought property values up for everyone, and how she had been systematically targeted by me from the moment I moved in. She proposed new HOA bylaws that would prohibit surveillance equipment that compromises community privacy and suggested a mediation process for minor disputes before legal action could be taken. Several of her supporters applauded when she finished, but I noticed that most of the room remained silent, watching for my response. When it was my turn to speak, I approached the matter differently than Patty might have expected. Rather than defending myself or attacking her, I focused on community standards and fairness. "I appreciate everyone coming tonight," I began. "I understand that litigation between neighbors isn't ideal, but neither is theft. The court has established that my water was repeatedly taken without permission during drought restrictions when we were all making sacrifices to conserve. I tried to resolve this privately first, but was met with threats and false HOA violation reports. I then addressed the broader issue. This isn't about one neighbor dispute. It's about whether we want to be a community where rules apply equally to everyone, or where certain people can take what isn't theirs with impunity." I concluded by suggesting that, instead of restricting security cameras, the HOA might consider a community-wide water conservation initiative that could benefit everyone. The tone of the meeting shifted when George Harrington, an elderly resident who rarely attended HOA functions, slowly stood up. "I've lived here for 27 years, he began in a gravelly voice, "and I've watched Patricia pull this same trick with 3 different neighbors. Back in 2018, she tapped into my sprinkler line when I was away visiting my daughter. Cost me over $1,000 before I caught her." One by one, other residents began sharing similar experiences, not just about water theft, but about Patty's pattern of reporting petty violations while breaking rules herself, harassing new homeowners until they conformed to her expectations, and using her HOA connections to intimidate people. Robert Chen looked increasingly uncomfortable as these testimonies continued, especially when it became clear that some current board members had been complicit in ignoring previous complaints about Patty. By the end of the meeting, the proposed changes to the HOA bylaws were unanimously rejected. Instead, the board agreed to form a special committee on community ethics and dispute resolution and to review all outstanding violation notices to ensure they weren't being used as retaliatory measures. Patty left before the meeting concluded, her small group of supporters dwindling as more neighbors spoke out. As people were leaving, several stopped to apologize to me for not believing the situation was as serious as it had been. The tide of community opinion had clearly turned. The following week, I learned that Patty had filed an appeal against the court judgment, but simultaneously listed her house for sale, a clear indication that she understood her position in the community had become untenable. Patty's appeal proved to be largely a delay tactic rather than a serious legal challenge. Samantha explained that the grounds for appeal were weak, focusing primarily on procedural complaints rather than disputing the fundamental facts of the case. "She's hoping you'll get tired of the legal process and settle for less," Samantha advised as we reviewed the appeal documentation. "It's a common strategy when someone knows they'll ultimately lose." Sure enough, 2 weeks after filing the appeal, Patty's attorney reached out to propose a settlement. "Ms. Wilson is prepared to withdraw her appeal and pay $6,000 immediately to resolve this matter completely," Mr. Holbrook offered during a phone call with Samantha. This was significantly less than the court-ordered amount, but it would avoid further legal proceedings and guarantee immediate payment. I considered the offer carefully. While pursuing the full judgment would be satisfying, it would also mean continued engagement with Patty and more legal proceedings. Samantha laid out the practical considerations. Appeals can drag on for months. Even with a strong case, there's always some risk, and you'll need to invest more time and emotional energy. This settlement would give you 60% of the judgment amount right now, with no further hassle. After some deliberation, I decided to accept the settlement with 3 non-negotiable conditions. Patty would need to pay 80% of the original judgment, $8,780, sign a legally binding agreement never to enter my property, and issue a public apology at the next HOA meeting. Mr. Holbrook pushed back strongly against the public apology, arguing that it was punitive rather than compensatory. After some negotiation, we settled on a written apology that would be included in the HOA newsletter instead of a verbal statement at a meeting. Patty agreed to these terms with obvious reluctance. The check she eventually provided included a memo line that simply read, "Final payment," the aggressive all caps and underscoring telling me everything about her feelings on the matter. The signed non-trespassing agreement was handled through the attorneys, and a brief, carefully worded apology appeared in the following month's community newsletter, acknowledging regrettable actions regarding unauthorized water usage without admitting specific guilt. With her house now officially listed for sale, Patty began the process of moving out. I occasionally saw her supervising movers or speaking with her real estate agent, but we never directly interacted again. The "for sale" sign on her lawn featured a different real estate company than the one that had sold me my home, suggesting that her previous connections in the community were continuing to erode. According to neighborhood gossip, she had been unable to secure a position on the HOA board of the new community where she was planning to move, despite her extensive experience. Apparently, someone had made a few phone calls to warn them about her history. The settlement money arrived in my account exactly as agreed. After reimbursing my actual expenses and setting aside money for taxes, I decided to use a portion of the remaining funds to host a community barbecue, explicitly inviting all neighbors regardless of which side they had taken during the dispute. This gesture was my way of demonstrating that my issue had been specifically with Patty's actions, not with the community as a whole. The event was well attended and surprisingly convivial, with many neighbors expressing relief that the tension in the community was dissipating. Robert Chen, the HOA president, pulled me aside during the barbecue to apologize privately for not addressing the situation more proactively when it first arose. "We let things go for too long because it was easier than confronting someone we'd known for years," he admitted. "That was a failure of leadership on our part." The newly formed ethics committee, which now included Samantha as an unofficial legal advisor, began revising the HOA bylaws to more clearly address issues of property boundaries and resource sharing. They also implemented a more transparent process for handling complaints, ensuring that no single board member could unilaterally issue violation notices without review. These changes, while seemingly small, represented a significant shift in how the community would handle conflicts moving forward, less based on personal relationships and more on fair application of the rules. The day Patty's moving truck pulled away for the final time, I happened to be working in my front yard. Our eyes met briefly across the distance, and while no words were exchanged, the message was clear. A chapter had closed for both of us. Within a month, Patty's house had sold to a young family, Michael and Jennifer Rodriguez and their 2 elementary school-aged children. They were immediately more neighborly than Patty had ever been, bringing cookies to introduce themselves and asking questions about the community. I debated whether to tell them about the previous owner's actions, but ultimately decided against volunteering the information unless directly asked. The community had moved on, and it seemed better to let the Rodriguez family form their own impressions without prejudice. When Jennifer mentioned plans to redesign their backyard, however, I did offer to help them understand the irrigation system and water restrictions, information they gratefully accepted. The HOA underwent significant changes in the months following Patty's departure. The Ethics Committee's recommendations were formally adopted, creating a more structured approach to rules enforcement and dispute resolution. Robert Chen stepped down as president when his term ended, replaced by Lisa Winters, a retired business consultant with a talent for organization and transparency. Under her leadership, the HOA created a community website where all rules, violation notices, and board decisions were publicly documented, eliminating the secretive approach that had allowed for selective enforcement in the past. The board also initiated a comprehensive review of all existing regulations, removing outdated restrictions and clarifying ambiguous language. Inspired by the water conservation discussions that had emerged from my dispute with Patty, Mark and I proposed a community-wide smart water management system. The concept was straightforward. Using similar technology to what I had installed to catch Patty, we could help the entire neighborhood monitor and optimize water usage, especially during drought conditions. The HOA agreed to allocate funds from the community budget to subsidize the installation of smart water meters for interested homeowners, with the goal of reducing overall neighborhood water consumption by 30%. The project generated unexpected positive publicity when a local news station did a feature on innovative community responses to drought conditions, highlighting our neighborhood's proactive approach. My unexpected involvement in HOA matters led to being invited to join the newly formed Sustainability Committee, where I found myself working alongside neighbors I had barely known before the dispute. Through these collaborative projects, I developed genuine friendships with several community members, transforming my experience of the neighborhood from a place where I simply lived to a community I felt connected to. Samantha organized a workshop on homeowner rights and responsibilities, which was well attended and helped clarify many legal questions residents had been uncertain about. These educational initiatives, combined with the revised HOA procedures, created a more informed and engaged community than had existed previously. The Smart Water Management Project proved even more successful than anticipated, with the neighborhood achieving a 42% reduction in water usage during the following summer. This success attracted attention from neighboring communities facing similar drought challenges, and soon Mark and I found ourselves being invited to consult with other HOAs about implementing similar systems. What had begun as a defensive measure against one neighbor's theft evolved into a community benefit and then into a broader environmental initiative. The local water authority recognized our neighborhood with a conservation award, which was proudly displayed in the community clubhouse, alongside photos of the implementation process. As the one-year anniversary of the court case approached, I reflected on how fundamentally the neighborhood had changed. New families had moved in, bringing fresh energy and ideas. The toxic influence that had shaped community dynamics for years had been removed, allowing more collaborative relationships to develop. During a sustainability committee meeting, George Harrington, who had spoken up about his own experiences with Patty during that pivotal HOA meeting, pulled me aside. "You know," he said thoughtfully, "sometimes it takes someone willing to rock the boat to fix what's been broken for years. Most of us just learn to live with her behavior because confrontation seemed too difficult. I wish I'd had your courage years ago." This unexpected validation from one of the community's oldest residents meant more to me than the court victory ever had. About 18 months after Patty moved away, I received a call from the HOA president of Oak Ridge Estates asking about Patricia Wilson, who had applied for their architectural review committee. I provided only documented facts about our litigation and directed him to the public court records rather than sharing personal opinions. Later, I learned Patty's application was declined, and she promptly listed her house for sale again. This final chapter in the Patty saga taught me valuable lessons. The legal victory was satisfying, but more important was learning to stand up for what's right, even when uncomfortable. Taking the middle path, careful documentation, attempting reasonable discussion, then using appropriate legal channels, not only resolved my individual problem, but catalyzed positive community change. The experience highlighted the importance of clear boundaries in community settings. Our revised HOA procedures created a framework where rules applied consistently and transparently, benefiting everyone. It proved that confronting problems directly doesn't destroy community harmony, but can strengthen it by addressing underlying tensions. The practical value of documentation cannot be overstated. Without video evidence and meter readings, the outcome would have been different. Technology provided both court evidence and evolved into a community-wide water conservation solution. What began as a defensive measure transformed into resource management innovation benefiting dozens of households. The court's decision to value water at $10 per gallon recognized that resources have contextual value beyond nominal cost. Patty's payment wasn't just for water, but for violating property rights and the principle that actions have consequences, even for those who believe themselves above rules. Standing firm despite pressure to keep the peace was perhaps my most personal lesson. Had I accepted Patty's $200 offer or been intimidated by her connections, both my situation and the neighborhood's long-standing problems would have continued. Sometimes being a good community member means challenging problematic behaviors rather than enabling them through silence. Today, my smart water meter remains installed, repurposed for our neighborhood conservation system, a reminder that the best response to exploitation is neither anger nor avoidance, but innovation and principle. Water has its price, and in our case, that price was paid in both dollars and justice. If you've experienced a neighborhood conflict or dealt with a Karen, share your story in the comments. Subscribe for more real-life stories and smart solutions every week.